Through this recording, I hope to remind you a little bit about the campaign finance reforms we talked about, as well as applying the ideas we discussed regarding activist courts to the Roberts Court in the area of campaign finance reform. The objectives are pretty straightforward. You want to be able to define activist courts, and as well as its opposite, the restrained court. You also want to be able to explain how the Roberts Court is an activist court, again, in the area of campaign finance. To reiterate or to remind you, activist courts tend to be less deferential to elective branches of government. Branches of government being plural because we're talking about the federal government as well as the state government. So the legislative and executive branches at both levels tend not to be deferred to as much as in a restrained court. Activist courts also are more willing to overturn stare decisis for ideological or legal reasons. They also expand or alter fundamental understanding of underlying constitutional precepts, and we will see that in the campaign finance decisions of the Roberts Court. The most famous of the activist courts was the Warren Court. In its case, Brown v. Board of Education, which was a 9-0 or 9-0 decision, unanimous decision, it overturned the stare decisis of Plessy v. Ferguson, which had established that separate but equal was not a violation of anybody's rights. The Warren Court said that that was not correct, and that stare decisis, that decision was not in line with the 14th Amendment protection of due process and equal protection clauses. The decision of Brown v. Board of Education did overturn segregation laws in many states, and even though it narrowly focused on school segregation, what it ended up doing was it created stare decisis for further decisions that led to desegregation throughout society. It is clearly an activist court. Earl Warren clearly wanted to bring justice to the system because Congress was unable or unwilling to act. Remember that some of the reforms that we talked about in campaign finance were contribution limits, spending limits, which were struck down in the Buckley versus Vallejo case of 1976, public financing, and public disclosure. These reforms were part of a law that came out in 1974, which was challenged almost immediately by conservatives who thought that this violated free speech. And ultimately, the Roberts Court, in its more recent decisions, has upheld that and has overturned some of the stare decisis. Buckley v. Vallejo did overturn the spending limits, but it did allow the other reforms. This is something that we will see undermined through the decisions of the Roberts Court. Remember that the 1974 law also established the Federal Elections Commission, which is an independent regulatory commission, and through delegated legislative authority, it established campaign contribution limits. And you can see here that you have the donors. In this case, you've got the individual donor, the candidate committee, the different types of PACs, and they're giving money to these organizations. For example, an individual can give $2,700 per election. That's $2,700 in the primary election and $2,700 in the general election to any number of candidates. Okay, but it can't contribute more than $5,400 to a particular candidate in a particular cycle there. That is new. There used to be an aggregate limit which limited the total amount that an individual could contribute, but that has been struck down in a Roberts Court decision of 2014, McCutcheon v. FEC, and thus an individual can make as many contributions to individual candidates within these restrictions. The Roberts Court really had been challenging campaign finance almost from the beginning. There were a number of cases that came before Citizens United that signaled that the Roberts Court was willing to challenge the fundamental law that was establishing the new regulations, and this was the Bipartisan Campaign Reform Act of 2002, also known as the McCain-Feingold Act. This law was also challenged, and what was being challenged was the legal restrictions on unions and corporations and other entities from showing political advertisements 30 days before a primary election and 60 days before a general election. This was originally upheld in the case of the McConnell v. FEC in 2003, but in 2010, the Citizens United decision got rid of that prohibition. What this ended up doing was it does overturn aspects of Buckley v. Vallejo, which was stare decisis. It also overturned the stare decisis of McConnell v. FEC. It did reiterate stare decisis that corporations were protected under the First Amendment, in this case, First Amendment speech. So what we see the Roberts Court doing is we see an activist court going out and challenging stare decisis. They rooted this in the Constitution, specifically the First Amendment right of speech. As we saw with Brown v. Board of Education, Citizens United v. FEC also overturned laws in many states that had similar restrictions on campaign advertising. This ultimately guts the McCain-Feingold Act and opens up the ability of unions, corporations, and just individual spenders to spend as much as they want and to air whatever speech they want as they deem fit. It's their money. It's their money, therefore they can spend it to support whichever candidate they want. The court did uphold the prohibition against coordination. Those people spending their independent money cannot coordinate with a particular campaign. That direct coordination is still limited by the FEC contribution limits noted in the previous slide. 4 years after Citizens United, the Supreme Court made another decision in McCutcheon v. FEC. Both of these decisions were 5-4 decisions, in which the conservative justices ruled 5-4 with liberal justices in dissent. For the first time in McCutcheon v. FEC, for the first time we see contribution limits being challenged. And in this case, what the court said was that the aggregate contribution limits that the FEC had established were unconstitutional, that you could not restrict the total amount of money that an individual could contribute across a number of candidates. They still uphold the specific contributions to specific campaigns or to individual campaigns at $2,700 per election, but they said that you can't limit how much money somebody can actually contribute. Ultimately, what you need to ask yourself is, you need to ask yourselves a couple of questions. One, what is the relationship between money and speech? Your answer will help determine whether or not you agree or disagree with the Roberts Court. Again, it is fairly clear that the Roberts Court is an activist court, at least in the realm of campaign finance. It is loosening the restrictions that previous stare decisis had allowed the legislative branch to enact. And through its decisions, it is expanding the understanding of political speech. By doing so, we then have to ask ourselves, is political speech able to be limited as other forms of speech? Speech is limited in a number of different ways. We can't say whatever we want whenever we want to. And that stare decisis does exist and has existed on the court through its decisions from the early 1920s through today. So one of the things that we need to think about is, how does this judicial activism fit in with limits on speech in previous decisions? Okay, so ultimately, hopefully you are able to remember certain aspects of the reform process. Remind yourself some of the discussion we had regarding the influence of money in politics, and then to also consider the Roberts Court as an activist court, not a restrained